As the Government of India celebrates 8 years of the Digital India program, Twitter has filed a writ petition in the Karnataka High Court against its order to block tweets and handles of users. Over the last decade, there has been a tenfold increase in broadband connectivity to 600 million broadband subscribers in India. But we need to assess, is mere connectivity enough to fulfill the democratic promises of the Constitution? In this context, let's understand Twitter case, IT rules and related spheres. So what do we need to know about the issue? So Twitter has legally challenged the government against its direction to block tweets and even handle issued by the Ministry of Electronics and Information Technology under Section 69A of the Information Technology Act 2000. There are issues with its own transparency mechanism in content moderation decisions. So however, it has been prompted to go to court to protect the integrity of its platform rather than in arrogant defense against the law of India. As per parliamentary data, the number of such order has risen from 471 in 2014 and 9,849 in 2020. So beyond mere numbers, a comprehensive qualitative assessment of such order is prevented by official secrecy. The need of disclosure emerges directly from a joint reading of the Shreya Singhal and Anuradha Bhasin judgment. So government and account takedown, recent disclosure in the last week of June 2022 revealed that Twitter withheld a number of accounts and tweets in India. Many of these belong to politicians, journalists, activists, and even a global think tanks such as Freedom House. So like similar situation witnessed in February in April 2021. So like in this context, so how does the government regulate digital speech? We need to understand this. So mandate social media to exercise greater diligence. So IT rules 2021 mandate social media platform to exercise greater diligence with respect to the content on their platform. So they are required to establish a grievance redressal mechanism and remove unlawful and unfitting content within a stipulated time frames. The grievance officer of the platform redressal mechanism is responsible for receiving and resolving complaints for the user. So draft amendment proposed, if I am talking about, so grievance appeal committee, it proposed an additional level of oversight, namely the grievance appellate committee, so functioning over and above the intermediate grievance redressal officer. So broadly, in a case of a user is not satisfied with the resolution provided by the intermediary, so he or she can apply appeal against the decision at the appellate rather than going directly to the court. Like Section 66A of IT Act 2000, it's empowered police to make arrest over what policemen in terms of their subjective discretion could constitute as offensive or menacing or for the purpose of causing annoyance, inconvenience. So prescribe the punishment for sending messages through a computer or any other communication device like a mobile phone or a tablet, and a conviction could fetch a maximum of 3 years in jail. Court struck down Section 66A as unconstitutional in 2015. It confers on the central and state government the power to issue direction to intercept, monitor or decrypt and information generated, transmitted, received or stored in any computer resources. So like in the interest of the sovereignty or integrity of India, defense of India, the security of the states, so friendly relation with the foreign state, public order, or for preventing incitement to the commission of any cognizable offense relating to these. So for investigating any offense, Section 69 enables to the center to ask any agency of the government or any intermediary to block access to the public of any information generated, transmitted, received or stored or hosted on any computer resources. So like if I'm talking about the challenge, this would have made the government the arbiter of permissible speech on the internet and incentivized social media platform to suppress any speech that may not be palatable to the government. So it will empower the government to censor speech on ground not stated under section 69A of the IT Act 2000 or article 19(2) of the constitution. So obligation on social media to resolve complaints. So draft put forth the obligation that all social media intermediaries resolve all complaints within 72 hours of reporting. So intermediaries are known to invest sizable time to truly scrutinize and determine the context of user account they are called to censor. So shortened timelines are therefore invited fear of a hesitant approach to get things done. Court observed that the weakness of section 66A lay in the fact that it had created an offense on the basis of undefined action, such as causing inconvenience, danger, obstruction, and insult, which do not fall among the exception granted under Article 19 of the Constitution, which guarantee the freedom of speech. So, like in this context, we can say, literally on the whim of their political master against the fundamental right. So, Section 66A was contrary to both Article 19 and 21 also of the Constitution. So, right to know is the basis of the right to speech and expression provided by the Article 19(1). So, making platform share more information could provide counterproductive in a country where the citizens still don't have a data privacy law to guard themselves against excesses committed by any party. So there is a need to expedite the passing of the Personal Data Protection Bill 2019. After that, if regulation is still deemed to be necessary, then it must be implemented through legislation that is debate in Parliament instead of relying upon executive rule making power under section 69 of the IT Act. So deliberating with stakeholders, there are indeed many problems with the new rules. But the major issue was that these were introduced without much public consultation. So the solution to ongoing criticism about these rules to start afresh, with the publication of a white paper. So that was all the discussion on digital speech. Thanks for watching.